Welcome to Lecture 5 of Constitutional Law. The topic of this lecture is the First Amendment. First Amendment includes freedoms of speech, press, and religion, plus a guarantee against the establishment of religion. Obviously, that's a lot of territory. In my law school, we have a separate 3-hour course on the freedoms of speech and press, and another separate 3-hour course on the religion clauses. No basic con law course can go into that kind of detail, and some of them omit the First Amendment altogether on the view that it's covered elsewhere. However, many of you in a basic con law course will have received at least some basic introduction to the First Amendment. In this lecture, we're going to prepare you to answer a con law examination question in that area. Let's begin with freedoms of speech and press. This is a vast, sprawling subject to which the Supreme Court adds new decisions every year. We can't cover all the details, but we can cover 3 foundational issues in the First Amendment. On any con law exam covering free speech, you would have occasion to refer to one or more of these 3 ideas. First are the doctrines of vagueness and overbreadth, which play a very distinctive role in the law of free speech. The second foundational idea is the distinction between content-neutral and content-based restrictions on speech. They are treated very differently, as we shall see. And the third foundational idea is the 2-tiered theory of speech. That is, the crucial distinction between speech that is and speech that is not protected by the First Amendment. Now, these 3 ideas in more detail, beginning with the doctrines of vagueness and overbreadth. Vagueness. If a law gives no clear notice of what is prohibited, it's vague. Let me say that again. If the law gives no clear notice of what is prohibited, it's vague and therefore invalid under due process. Overbreadth. If a law burdens substantially more speech than is necessary for a compelling interest, it's overbroad. Note, substantially more speech than is necessary for a compelling interest. Virtually any law will be overbroad to some extent, but substantial overbreadth violates the First Amendment. Now, the best example is nudity in drive-in movies. Some nudity in drive-in movies is legally obscene, and obscenity can be banned. But some nudity in drive-in movies is merely very large, and the Supreme Court has said that very large nudity is fully protected by the First Amendment. So a law that bans all nudity in drive-in movies is unconstitutionally overbroad. Why? Because it bans some speech that can be prohibited, legally obscene nudity, and it goes substantially farther and bans other speech that cannot be prohibited, non-obscene nudity. That is, by the way, not an example that I made up. It's a real Supreme Court case, and it nicely illustrates the overbreadth doctrine. That doctrine is extremely unusual. Ordinarily, you can challenge the constitutionality of a law only as it applies to you. Ordinarily, you cannot attack a statute on the grounds that it might be unconstitutional as applied to someone else. But the overbreadth doctrine allows persons whose speech is not protected by the First Amendment to challenge a law on the ground that it covers protected speech by someone else. That's so important, I want to say it again. The overbreadth doctrine allows persons whose speech is not protected by the First Amendment to challenge a law on the ground that it covers protected speech by someone else. That's called facial review. If the statute is substantially overbroad, it is invalidated on its face, that is, across the board. And this extraordinary result is justified to avoid the chilling effect that the statute might have on protected speech. Well, of course, chilling effect is simply another name for deterrence. All laws have chilling effect, that's the point. Antitrust laws, for example, might intimidate some from engaging in perfectly lawful business transactions that seemed close to the line. Laws against selling liquor to underage persons might inhibit some sales to borderline persons, lest there be a mistake. These are all examples of unwanted or unintended deterrence, or, if you prefer, chilling effect. So why do we have overbreadth doctrine under the First Amendment and nowhere else? And the answer is very simple. The overbreadth doctrine reflects the judgment that free speech is simply too important to be chilled. At bottom, the overbreadth doctrine and the policy of facial review reflect the judgment that free speech is special and must be specially protected. A second foundational idea in the law of freedom of speech and press is the distinction between content-neutral and content-based restrictions on speech. Content-neutral regulation of speech is dealt with under the heading of time, place, and manner regulations. By definition, regulation of the time, place, and manner of speech is not regulation of content. Now, what kinds of things are we talking about here? Well, do you have the right to harangue us with your views on President Clinton? Yes, of course. Do you have the right to do that in this room in this hour? No, you do not. Do you have the right to use sound trucks to advertise your political opinions? Yes, you do. Do you have the right to use them in a hospital zone at 3 a.m. and keep the patients awake all night? No, you do not. Do you have the right to parade, to protest, to demonstrate in public parks or other appropriate places? Yes. Do you have the right to parade or protest inside a courtroom or inside the premises of a prison? Answer, no. Those are time, place, or manner regulations. In the real world, they're extremely common. Most of them are not terribly controversial. When they are challenged, they are usually upheld. 3 requirements for a valid regulation of the time, place, or manner of speech. This bit of doctrine, by the way, has more payoff than anything else you can learn about freedom of speech and press. 3 requirements for a valid time, place, or manner regulation. First and foremost, the law must be content neutral. Here's a great example of a statute that failed that test. The District of Columbia had an ordinance barring picketing anywhere within 500 feet of a foreign embassy. Now that sounds like a simple regulation of place, but the ordinance only barred picketing if the signs called the foreign government into odium or disrepute. In other words, you could stand at the gate of the British Embassy with a sign saying something flattering to Her Majesty, God save the Queen. That was perfectly lawful. If you stood in the same place with a sign of equal dimensions saying something rude to Her Majesty, that would violate the D.C. statute. That's a content-based statute, even though it purports to regulate place. And it was struck down on that ground. Not only must the law be content neutral on its face, it must also be neutral as applied. What that means in practice is that a valid time, place, or manner regulation cannot vest discretion in an executive officer. Make sure you see the connection between executive discretion and content bias. If an executive officer has the power to pick and choose among speakers, the power to pick and choose among messages or points of view, the risk is that that officer will allow speech with which he or she agrees and disallow speech with which he or she disagrees. The risk is that there will be a content bias in the administration of the law. Time, place, and manner regulations must be content neutral both on their face and as applied. Now, this is a very important idea. The Supreme Court says we will strike down a statute which gives an executive officer the power to pick and choose, even if there has been no demonstrated content bias. In other words, the Supreme Court says we will not wait to see whether the law is administered even-handedly. We will simply strike down a statute which gives executive discretion in order to avoid the risk of content bias in administration. There are lots and lots of examples of that principle. Here's an easy one. A parade permit requirement imposed a fee of up to $1,000, but it left the amount of the fee, anywhere from $0 to $1,000, in the discretion of a county administrator. Held unconstitutional. Why? Because the county administrator had discretion to charge more or less and might well have charged more for unpopular speech. So the law must be content neutral on its face and as applied. Second requirement. The law must allow substantial other opportunities for speech to take place. Substantial other opportunities for speech to take place. In other words, it has to be a guideline, not a prohibition. Basically, these are housekeeping rules. Example, statute that says no amplified sound in residential neighborhoods from 11 o'clock at night until 7 in the morning. That's perfectly valid. Lots of other times, lots of other places for you to sound off. The statute that says no use of amplification anywhere in this jurisdiction would be struck down. Comes too close to a flat prohibition on speech. Third requirement. The law must be content neutral. It must allow substantial other opportunities, and it must narrowly serve a significant state interest. Narrowly serve a significant state interest. Note the absence of the buzzword compelling. The government interest behind a content-neutral regulation of the time, place, or manner of speech need not be compelling. It need only be significant. And in practice, that is not a terribly demanding test. Now, if you think about it, here's what the Supreme Court is telling us. When the government regulates free speech, what is the real risk? What is the great danger that we most fear? Answer, that the government suppresses a particular point of view, that the government disadvantages a particular candidate or party, that the government stifles dissent. By definition, time, place, and manner regulations are content neutral. By definition, they do not carry the risk of suppressing a particular point of view. Therefore, says the Supreme Court, the test is less demanding. Significant state interest, and in practice that means virtually anything that makes sense to a judge. You heard a few minutes ago that content-neutral regulations of the time, place, or manner of speech are often upheld. Indeed, I would say usually upheld. They're really rather common in this country, mostly at the level of municipal ordinance. Content-based restrictions on speech, in contrast, require a compelling government interest. Content-based restrictions on speech are typically struck down. Good example of a recent controversial case involving a content-based restriction on speech was the law against flag burning. The justices agreed that the statute was content-based because it allowed citizens to use the American flag to express their reverence for the country, their love of the country. It did not allow citizens to use the American flag to express their hatred or contempt for the country. Therefore, the law against misusing the American flag prohibited its use in conveying a certain message. The law was content-based. Now, the justices all agreed that a compelling government interest was therefore required. They split down the middle on whether that interest had or had not been demonstrated. A minority of 4 justices thought that the flag was so special in its symbolism of all that is best in this nation that prohibitions on the misuse of the flag should be valid even under the compelling interest test. But a majority of 5 justices disagreed and struck down the law against flag burning as a content-based restriction on speech. The third foundational principle that we need to cover is the 2-tiered concept of speech. Generally speaking, a law that regulates speech based on content will be struck down. That is, generally speaking, the government has to show a compelling reason for content-based regulation, and that is very rare. But there are some categories of speech for which strict scrutiny does not apply. Some categories of speech that are altogether outside the protections of the First Amendment. So long as the law is not vague or overbroad, a statute prohibiting speech only within one of these excluded categories is perfectly constitutional. That's what I mean by the 2-tiered theory of speech. That is, that there is some speech in the First Amendment and some categories that are not. What are the categories of unprotected speech? Here are 3 important examples. First, obscenity. There are huge problems as a practical matter coming up with obscenity laws that are not vague and overbroad. As all of you know, drafting a good obscenity statute is very difficult. And once you write it, there is still uncertainty in its application. So vagueness and overbreadth are problems in obscenity. But if you can draft a valid obscenity statute, they're perfectly constitutional. Why? Because, says the Supreme Court, obscenity is not protected speech. It is a category of expression that is altogether outside First Amendment protection. Here's another example: false statements of fact. False statements of fact can generally be suppressed. There are lots of examples of laws based on this theory. Laws against perjury, against fraud, laws against misleading or deceptive advertising, laws against libel and slander. In all these cases, the laws are consistent with the First Amendment in that they suppress false statements of fact. Now, emphasize the notion that there is a statement of fact, something that can be proved true or not. Under the First Amendment, there is no such thing as a false idea. But the government can suppress false statements of fact. For example, the statement that certain real estate is prime building property when in fact it is undrainable swampland. That's fraud and can be punished. All of you know, if you studied the law of defamation, the law of libel and slander, that there are constitutional rules in that area designed to build in some breathing space so that over-deterrence will not be a problem. But the false statement of fact by itself has no First Amendment value. Third example. Apparently it is still true, though it has been controversial for years, that fighting words are not protected speech. Fighting words are words so assaultive as to be a trigger to violence. Today, many fighting words issues arise under the label of hate speech, including, for example, racial epithets. Now, it's extraordinarily difficult to draw a fighting words statute, a hate speech regulation that is not vague and or overbroad. Indeed, I think the experience in the lower courts has been that these laws are generally struck down on grounds of vagueness and or overbreadth. Extraordinarily difficult to draw a fighting word statute that is not vague or overbroad, but the Supreme Court says that if you can, fighting words are not protected speech. Well, we've covered three instances, three categories of speech not protected by the First Amendment: obscenity, false statements of fact, and fighting words or hate speech. What do these categories of excluded speech tell us about the First Amendment? Well, the first and most obvious thing they tell us is that speech itself is not constitutionally protected. Only the freedom of speech is constitutionally protected. That's such an important point, even though it's an obvious one. Let me say it again. Speech itself is not constitutionally protected. Only the freedom of speech is constitutionally protected. And what the freedom of speech includes is a matter for interpretation, not identification. In other words, to tell what the freedom of speech includes, you need a theory, a rationale, some idea of why speech should be constitutionally protected in the first place. Now, one theory that fits these decisions remarkably well goes under the label of the political speech principle. This is one of the main theories to explain what the freedom of speech includes. The political speech principle relates the First Amendment to the structure of the government set up by the Constitution. It says that the core idea of free speech, not necessarily the only idea, but the core idea of free speech is to protect speech relevant to self-government. Speech relevant to self-government is political speech, broadly conceived. It includes not only campaign speeches by politicians, not only electioneering speech, but it includes any public discussion of public issues. This is a systemic rationale for the First Amendment, one that focuses on the value of speech to societal decision-making, rather than on the value of the speech to the individual who utters it. There is, of course, a contrary approach, an approach that focuses precisely on the importance of speech to the person who utters it. This is usually called individual self-fulfillment, or sometimes individual self-realization.